Hi, my name is Ted Carr. I'm a partner with Berkeley Law and Technology Group. My practice focuses on trademarks primarily, but I do handle all forms of intellectual property. And today I'm going to be answering a question that I get very regularly from potential clients and new clients. And that question is, when can I start using my trademark? And do I need to register my trademark before I can use it? And the short answer is no, you don't need to register your trademark before you use it. You can use your trademark as soon as you're ready. As soon as you've developed your brand, you can actually start using your trademark in association with your product or your service, or the combination of both. One thing to keep in mind is if you've not registered your trademark, your rights are protected under the common law as opposed to state trademark rights, or the state trademark registration, I should say, or the federal trademark registration. We'll talk about those in another video, but I just want to talk about common law rights here for a moment. What are common law rights? Common law rights means there's a doctrine of law. It's basically governed by state law, but also is touched on by the Lanham Act, the Federal Lanham Act. And it basically says whoever starts using the trademark first in commerce has a priority. So if you start using your mark in commerce and no one else has used the same or similar mark in association with the same or similar product or service, then you would have priority, and those common law rights would give you priority over even someone who registers a trademark after you started using your mark in commerce and you're only relying on your common law rights. Now, there are some exceptions to that. For instance, if you are in say Dallas, Texas, or Austin, Texas, and you start using your mark in commerce, and then someone else registers the same mark with the Patent and Trademark Office, they may be infringing on your rights if they decide to use their mark in Dallas or Austin. But if you decide, for instance, to use the mark in New York and you hadn't been using it there before, then your common law rights would not extend that far, so they would have a priority in that jurisdiction. So your common law right basically will grant you an exclusive right to use that mark, but only in the territory or geography in which you're using it. And it gets a little muddy when you start talking about, like if you had a service business, an online website, presumably and arguably that covers all 50 states. So you may have broader rights even under the common law. When might you want to rely only on the common law as opposed to registering your trademark? Well, let's say we perform a search and we identify something that we think an examiner is going to raise as a potential likelihood of confusion, but we really don't think there is a likelihood of confusion. In that case, you may not pursue federal registration or state registration, but you may still use the mark in commerce and hold it out as a trademark. When you're using a mark under the common law, you use the TM symbol, not the circle R. The circle R is basically reserved for federal registration. So if someone beats you to the basically you start using the mark, someone beats you then to the federal registration process for the rest of the country, you may want to rely on just your common law rights. Otherwise, I would encourage you, even if you are using the mark in commerce under the common law, to look at and consider state or federal registration. We're going to talk about that in the next video. And the biggest issue is if you only rely on your common law right, you may get boxed in and you may not be able to expand your business like you would like to. So if you're interested in the state registration process and the federal registration process, check out the next video that I have. Thank you.